that, my lord. Give consent for obtaining United Kingdom visa. So, is this court about the consulate of UK saying you give them visa? Can this court direct? Well, these are all applications which are not even maintainable, because no court in India, even Supreme Court, can't give this decision. Under Article 142 to the UK consulate, give them visa. And passport is not your and my property, it's the property of the Union of India. Passport doesn't belong to us. Then give consent for any requirement from passport. How can your lordships grant these prayers, my lord? Are we sitting over the passport officers, over the consulate? It is ridiculous. It is ridiculous, because this court does not even have jurisdiction, even if it wants to help him. Even Supreme Court doesn't have jurisdiction, my lord. Let my statement be recorded. These prayers can't be given even by the Honorable Supreme Court. Can the Honorable Supreme Court give a direction to the consulate of UK? You give him visa. What if you are not qualified? It is within the discretion of the consulate of UK. Go, apply. If they don't come back, file a writ petition. If your passport is not renewed, come back to High Court. That is regarding passport and visa. Does this court have jurisdiction even to entertain an application, even if I don't file? One. Next is, my lord, hierarchy of courts, interim orders, my lord, the first citation. Even in this first citation, this is the one. No, yeah, this is the one. Even this, my lord, is against an interim order passed by the. Even here, application is filed in the trial court, then High Court, then the Honorable Supreme Court. Come to that date. His first citation, which he cited, my lord, under Hindu Marriage Act, was the first citation. That is, my lord, 2010 AC 1675. Now let us see here also, my lord. In the instant case, that is at left side, my lord, bottom, in the head note, in the instant case, a divorce was granted by mutual consent. Divorce was already granted. The terms and conditions to custody of the boy child were contained in the petition for divorce for mutual consent. So, only what they had agreed, if they don't comply, what was the order? And that too there, my lord, kindly see para 2 of the judgment. This appeal by husband impugns the impugned judgment and order of Delhi High Court, which upheld the judgment of the family court under section 26 of Hindu Marriage Act. So can you overlook 26 and say, I don't want 26, I'll come under 227. I don't want 227, I'll go directly under 142. You can't do that. Hierarchy of court, that's why only one citation regarding, I don't think I should be, because it's agreed regarding hierarchy of courts, my lord. But still, sorry. Hierarchy of courts, which one is? Give to the court. Now, what is hierarchy of courts? It is not simple expression or term. Para 29. Can this court usurp the jurisdiction it is? It is not technical aspect, it is the jurisdiction is family court, para 29.
Yes.
I can understand if it is technical, hyper-technical, procedural, handmaid of justice, CPC is a handmaid of justice, because, my lord, it is a civil procedure code. It is not civil procedure act. Why is it not called an act, and why is it not called as a code? Because it is the procedural code which is exhaustive in nature. You can't look beyond that code. Therefore, it's called as a code, criminal procedure code. Why it is not called? And there are certain reasons. They are procedural, but still they are codes which are exhaustive. Here, it is under the Act, Family Courts Act. I have to go before the family court. If I want to file a divorce petition, I'll file directly under Article 227. I'm in a great hurry. I want divorce. I want to get married. I don't want to waste my time in family court. Kindly grant me divorce. Can I come? Because the Act says no. When Act says no, you go to the jurisdiction it is. That is why kindly see para 29. I have 2, 3, but let me just read this. It is difficult to appreciate the anxiety of the division bench of the High Court. Now, this is what he is asking your lordships to do. Anxiety. I want time. There is no time. Kindly pass orders. To dispose of the interlocutory application instead of relegating it to the court below for disposal. That is precisely I'm saying. Why should this court be anxious? There is no anxiety. And there is no stay. Why did you not file there? I can understand he had an impediment there in filing. Who prevented him? Even today morning, you go file it right now. We'll file objections. All your facts will contest. The Supreme Court citations will let the learned family court also hear what is your case. Then your lordship will appreciate as sitting as a higher court. I can't ridicule and reduce your lordship to a family court judge and bring all these things. Whether he's studying, he's got good certificate. Is this court meant to do all that? No. Kindly see, my lord. When division bench of High Court itself took 8-9 months to decide the appeal. Now, how many years is this writ petition pending? When the division bench of High Court itself took 8-9 months to decide, it is difficult to understand as to what the learned judges of division bench of High Court meant by unnecessary prolongation of litigation and utter wastage of time. That's what he wants your lordship to write. If it goes before family court, it's a waste of time. And had been never even been thought on those lines, my lord. Waste of time. If the learned judges of division bench were so much concerned with the prolongation of litigation, they could have very well requested learned single judge. Kindly see here, instead of single judge, your lordship will request the family court. Family court application within a stipulated period. That is what your lordship said. 1 week, and that is the correct procedure with due respect. What? Instead of waiting for a period of 8-9 months, this could have been done by them at the very first instance when appeal was listed. When has he filed this application? See the date. Just to prevent, after all the 9 orders are passed in my favor, he comes out with this application. November 2024. When were those 9 orders passed? March before that. What prevented you from filing then? So he doesn't. The last order which his lordship Justice Kinigi passed, just before that he files his application because he did not want me to take the child to Bombay. It's only preventive. My lord, even if she's a doctor, the topmost surgeon in India, she will not get a job in UK because you have to pass their exams, they have to be invited, contracts will be there, and that too will be given for 2 months, 3 months, and she has to come back. Permanently, the Prime Minister is not going to invite her and give her citizenship and a job. It's not so in UK law. I know what the UK laws are. It's not so simple. Let me continue to read this, my lord. Yeah, this hierarchy of the trial court. Kindly see that word, my lord. This is what I've been arguing. The hierarchy of the trial court and appellate court exists so that trial court exercises its discretion upon certain principles of law. So it is not procedural, my lord. Hierarchy is created by the constitution of this country, giving me a right to appeal, giving me a right to approach a second appeal. Is a constitutional right, my constitutional right and procedural right, appellate right to come before your lordship. My lord, I have a constitutional right under Article 227 to come before your lordship and say, look, that order is wrong. So you want to take away my constitutional right of coming before your lordship? That's what he wants. Urgency. What urgency? Why are you sleeping here then? What prevented you? That's what the Supreme Court says, my lord. An appellate court, the hierarchy of a trial court and appellate court exists so that the trial court exercises its discretion upon settled principles of law. An appellate court, after the findings of the trial court are recorded, has an advantage of appreciating the view taken by the trial judge and examining the correctness or otherwise thereof within limited area available. Because, my lord, your lordship is not sitting under the original jurisdiction of a family court where I'm going to cross-examine. Supposing I file an application tomorrow, his documents I need to cross-examine because they're bogus. Can we set up a witness box, put him here and examine? Is that's the role? Here it is limited. That's what they say, my lord. Limited area available. If the appellate court itself decides the matter, required to be decided by trial court, there would be no necessity to have hierarchy of courts. We'll abolish family courts. We can even abolish High Court and go directly under Article 32. As observed by this court in so and so, the appellate court cannot usurp jurisdiction of the single judge to decide as to whether tests of prima facie, balance of convenience, these are made out or not. This is only one of the citations. I have other citations, but they're all the same. They repeat. Not be required. Not necessary. So, if your lordships what your lordships said in the first thing is correct. Go there and file there. And hierarchy of courts, my lord, is a constitutional this thing. It is not some procedural aspect saying that you ignore it. So IA number 2 prayer cannot be granted even by the Supreme Court, my lord.
No, he is not seeking visa authorities to grant visa. What he is seeking is a A consent to
Let
give
the trial court
passport,
consider.
consent of the father.
Even if I give consent, let us assume.
But he has very
You know,
effectively
1 minute,
misread it.
1 minute, even if I give consent, visa can't be granted. It is for the authorities in duty. So let the trial court consider whether, supposing trial court says you give consent, I'll come before your lordship saying that he has no jurisdiction to say that.
Merely by consent given by either husband, father or mother,
You can't get.
visa may be rejected by the
Yes.
visa
That's a
authority.
different thing.
No,
That is
what I'm
altogether
saying is
different, my lord.
my
That's
right-
altogether different.
Please, 1 minute, I didn't interfere. My right to come before this court, in case the trial court accepts and grants it, is the erroneous order, I'll come and point it, my lord, this is an erroneous order.
Yes.
So you want to take away my constitutional right of coming before this court under
Right.
Article 227?
All.
That's it. Oblige.
May I make only one submission? All this submission to drive me back to the family court is only to delay the acting. It's delaying. It
Not driving, that is the original proceedings you should have gone.
by delay, what would he achieve? Is only his satisfaction that he has prevented me and my son to go abroad. That's all. Nothing beyond that. Whether this court passes an order, Supreme Court, yes, in that the second judgment of 2023, it's under 142. I don't deny that. That's why I read that. In fact, I did not skip that portion and read only the relevant portion of technicality. It's 142. But the previous judgment of 2010 was not under 142. I only read those two judgments related to apprise your lordships as to what is the position of law that the Supreme Court laid down in cases where mother wants to take the child out of the custody of out of the country.
All
That's
right.
all. But after all this, my submission is, if my lord for any reason feels that I should go back, as my lord, it's an alternative submission. As my lord was pleased to observe that the family court can be directed to dispose it of within this very same IM, since he has already filed objections and since no evidence need be recorded, it's only straight case of giving or no giving,
This
not
is-
giving. That
He
will
has
do
to
it.
file fresh IA in family court. This can't be
But
transferred.
This attitude is not right, my lord, on the father.
That is the
on
law.
part of the father. He wants to prevent me.
That is the
What-
law. Sir, that is the
Hey,
law.
What does he gain?
That is the law,
No,
sir.
he-
You
he-
can't take the writ petition and make it into an
You
IA.
can't
sir.
take the refuse of law or the constitutional right to prevent the wife and son to go abroad for a better living. This is the nature of the father.
No,
And he,
I don't know whether it is going to be better living outside India.
India.
it's a different thing, but she wants to do that.
There is a misconception by most
But
most
what-
of the Indians
One more
that
reason.
by traveling to outside country or either UK, Europe, United States of America, Australia, Canada, or UK, that you are going to have a great and better living.
No.
Not all. Many may suffer because I have my,
You are still going to be treated as second-rated citizen in any other country other than India.
India.
Simple
And
as that.
even as a tourist,
Of course, I agree with you that there is better quality of education, no doubt. But you will still be treated as second-rated citizen. You will still not be offered Oxford or Harvard. Please take it from me.
not all.
even as a
not
tourist
all,
when we go.
Not all.
No,
Because in Canada, in one university where the minister of this country went, just about 6 years ago, of the 32 departments, 31 were headed by Indians.
Hmm.
Then the question was asked by this minister who interacted with me personally to find out as to how Canada can grant you so much. He said the answer of the professors was that here, unlike in India, things are decided on merits. People will be selected on merits. Just because somebody else is somebody's son, he or she will not get appointment like in India.
correct, that is true.
So therefore, and the reason for my making an application at this point of time is not as what he said. I did not complete my examinations. Only after I completed my examinations, I filed this application. Before, and it's a government job. So therefore, the matter must be viewed from the angle of all the parties, not from the angle of only a father who is very keen to prevent his wife and to go abroad.
He's
I may
not-
suffer or I may not come back.
It's not preventing you from going.
Constitutional right to oppose everything that I do.
No, he's not at all preventing the wife from going wherever she wants to go. He's only concerned about the
The
visitation.
Well, if it were only that much, I need not have filed this IA at all. Because I filed this IA to ensure the better prospects of my son. But the court may decide otherwise. I do not say that. My lord, also we have seen just 15 days ago how Indians were chained and brought back. because they were all illegal immigrants.
No, they were changed because they should not commit suicide in the aircraft. That is also another reason
It's a
because of
different thing.
depression.
See,
There
but
are reasons, pros and cons for both, since you're
many
raising
Indians-
it.
Many Indians do have misconception about the fairy tale success stories in abroad.
Correct.
My lord, anyway, my lord, highly obliged, my lord. Can we just, I got
Yes,
another
yes,
matter.
yes, yes.
Highly obliged.
Please, that's all, minute. The alternative submission, if my lord is not pleased to consider my first
So do you
submission,
want an order on merit on this IA of yours?
I leave it to your lordship.
Or
I
if
have
you-
made only my submissions. I'm grateful to your lordship.
No, if
Because-
you agree that this matter back to the family court, I will say so. If you want an order on merit, I will pass an order on merit, passing how your application, whether sustainable or not, or should I grant or not.
Milord, if the matter ultimately is to be sent back to the family court, an order on merits may not be necessary because that would again come in conflict and would confuse the family court.
Correct.
And now that Milord IA can be considered within a week, as your lordship please observe, a consent order may be passed.
Consent, take it.
Consent,
You don't have
allow.
right? No
No,
consent.
he said yes.
No,
See,
no.
what will happen
You
for
filed
your
there, no
benefit
consent.
also,
Why should I consent?
even if you have not filed anything, and if you want to place any material.
Go do that.
No,
That's all.
except this minute, your lordship was pleased to observe that there is very same IA will be directed to be considered by the family court. The same may kindly be done.
Markot.
IA number 2.
So this is going to be only orders on IA number two
Two,
and
please,
not on the petition and what is
Well,
filed by.
petition also can be disposed of on my submissions made. One permanent settlement might be made and disposed of. Why should it be pending is my submission.
What is your submission on
No,
that?
so far as is IA number 1 or the disposal of the writ petition itself is concerned, but I can't say, I can't have any say because it is his discretion. He has come here and he wanted to challenge the order passed by the family court. If he doesn't want to within a week.
Where is that application which you mentioned?
Page 19, my lord. 19, annexure C.
In the memo, is it?
In the memo itself, I have produced along with the writ also, but in the memo I have produced for convenience sake, my lord. Page 19,
Yeah.
annexure C.
Yes, yes.
That is my prayer.
See, if I have to dispose of the petition as well as IA number 2, his petition for grant of this order of visitation rights, which is
But that can also be considered by the family court only.
No, no, no,
The
no.
change in
No, 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 no,
visitation
no. It is,
rights.
no, 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 no. That's under challenge.
Honorable court passed visitation rights during the vacation only on the applications filed. So
No,
no
that is-
final order is
no,
passed
no,
on
no.
the family court's order. It can
No.
be considered.
No,
writ petition which is filed by him.
Please.
on orders passed on this IA.
Is questioned on IA number 3 filed by him.
Yes, and orders passed then on.
And the orders passed.
No, he
That-
wants to, he has filed an IA here to amend the petition in the family court, which can't be done. Because an amendment petition can be done only in the family
Amendment,
court.
I'm not pressing here, my lord. I'll file. I'm not pressing.
That may be recorded. Amendment if he is not pressing.
Here, that I'll press it before family court. I mean,
Now, what is questioned is the orders, impugned order of the family court, whereby the entire relief sought for in IA number 3 is not granted. It is reduced to only some few hours in the morning or Saturday and Sunday. After that, this court has passed orders, several orders, granting him visitation
During vacation.
during visitation.
Only during vacation.
Visitation, so many other things.
No,
But nothing-
visitation during vacation, my lord.
Correct, sir?
Not other times.
You are agreeable with that? I will pass an order, dispose of the writ petition.
No, my lord, my kindly consent. My lord, if my IA were to be considered or are against, that will have a repercussion on the visitation application filed by the father also. Therefore, that has to be considered first.
Which one?
My lord, the IA number 2 filed here, which my lord is pleased to direct the family court to consider. If that is considered, the entire visitation rates will be, my lord, a different panorama. Therefore, that has to be considered first. If it is dismissed, that's a different thing. If it is accepted, then family court also will have to reconsider the visitation rates of the father.
Fact remains that you have parted with custody visitation rights. This court has granted him visitation and custody rights
No,
during
but
vacations.
During vacation.
He cannot wait for the family court or this court to pass an order on IA 2 and thereafter decide when
My
the
lord,
father
your
has to meet
lordship
the
said
child.
only 1 week. IA 2 will be decided only in 1 week. That can be
I may
considered.
not say 1 week. I may not say 1 week. You have read the latest judgment
Decision
of the Supreme Court, which says this court, the
They are
high
not
courts
fixed
do not
time.
have powers to fix
Then my
time.
lord, my lord may kindly pass an order of merits on my IA number 2.
very, on both the IAs.
All right.
Goble.
Then what about the main petition?
It is left to him, my lord,
No,
whatever he wants to do.
Want to argue on the main petition?
Not now, my lord. My IA2 may kindly be considered now. On the main matter, I'm not prepared to make submissions on the, my lord, the merits of the writ petition.
Yes, record it. Heard. Learned Senior Counsel, Shri. This is serial number 21. Shri
Gangadhar Gurmat
Mandagi,
for the wife.
Senior Counsel Shri Anant Mandagi for appearing on behalf of Kaveri Kimaya for the petitioner, father, and learned Senior Counsel Shri Gurnath Gurumathal,
Gurmat, Gangadhar Gurmat.
Gangadhar Gurumat.